President.
Leader of the Opposition.
President, I move private members' business item number 2254 outside the order of precedence standing in my name relating to censure of the Leader of the Government. Mr President, the Opposition does not take this step lightly or inadvisedly. We have given it careful thought and consideration. Sadly, the intransigence of the Executive Government of the day leaves us, and I believe this House, little choice. Should we as a House of Parliament not take this step, we diminish a key tool that provides effective scrutiny of the Executive by the Parliament to guard the public interest on behalf of the wider community we all serve. Mr President, if you look at the resolution or the motion 2254, you'll see that we seek to censure the Leader of the Government as the representative of the government in this place, not for its failure to comply with one call for papers, not for two calls for papers, but for three. And it's quite an accumulation of important public policy matters that are encapsulated in those three matters. There is the resolution of the House of 15 March relating to Sydney stadiums in respect of certain documents, including business cases. There is the resolution of 12 April 2018 relating to the preliminary and final business cases for the relocation of the Powerhouse Museum from Ultimo to Parramatta. Both of those two matters are not only matters of public controversy, but matters involving very considerable amounts of public expenditure or proposed public expenditure. The bases of those decisions are contested not only in this place and in the Parliament more generally, but throughout the wider community. The third call for papers is the resolution of this House of 17 May 2018 relating to the final report and final draft report of the independent review of the out-of-home care system in New South Wales, the Tune report. This, of course, relates to the state's care and protection of some of this state's most vulnerable citizens. A very important matter. The government used public money to commission a report from Mr David Tune, an esteemed former senior public servant at the Commonwealth level, but that document has not been seen. And it's called for by this House so that we can see what was recommended to the government, so we can judge the performance of the government in this important area of public policy by the yardstick of that report. In relation to the Sydney Stadiums matter, the Honourable Linda Volz and I identified documents in the call for papers which we thought were missing, including business cases. On the 15th of May, I wrote to the clerk, and the clerk communicated with the Department of Premier and Cabinet, who made inquiries, and it was reported back to this House that there were no documents caught by the order of the House and which were legally required to be produced. And it's that second part that this resolution, and I think this House, ought to take issue with. So we have here three very important matters where this government has, with reckless indifference, thumbed its nose at the resolutions of this House in a way not seen since the mid to late 1990s in this place. Now, this House has undoubted power.
I remember that vividly. I remember it vividly.
I have nothing against the Honourable Michael Egan. Now, this House, as members would be aware, has undoubted power to compel the production of state documents held by the Executive and state agencies. The Leader of the Government acknowledged as much in this place during question time on the 1st of May. However, on that occasion, he also stated, and I quote, "However, the New South Wales Court of Appeal in Egan and Chadwick concluded that the power of the House to compel the production of documents does not extend to Cabinet information. Cabinet documents are neither identified nor produced in response to an order," unquote. The Leader of the Government then proceeded to read extracts from the Premier's Memorandum M 2006-08 maintaining confidentiality of Cabinet documents and other Cabinet conventions as a justification for this position by the Executive, on the basis that previous governments had done it too. Mr President, this does not make it correct. Mr President, the position taken by the government in this place today, the government of the day, is based on a very careful misreading of the judgments of the New South Wales Court of Appeal in Egan and Chadwick. The head note to Egan and Chadwick in 46 New South Wales Law Reports 563 confirmed the power of this chamber to require from the executive state papers pursuant to its common law powers regarding its function in holding government to account. However, and I quote from the head note, in respect of cabinet documents, their immunity from production is complete, unquote. However, as has been noted by many eminent legal scholars and commentators since, including Mr Brett Walker SC in his paper Justified Immunity or Unfinished Business, the Appropriateness of Parliamentary and Executive Immunities in the 21st Century, given last year, this is not in fact what the Court of Appeal decided in that matter. Mr President, what did the court in that matter decide? Starting with Justice Marr, His Honour found, and I quote from paragraph 153 of the judgment, as far as documents which are covered by the doctrine of public interest immunity are concerned, I cannot see how the Legislative Council is in any different position. The court cannot possibly prohibit the council from examining such documents. However, there is a third category of document in question, and that is cabinet documents. With regard to these, I am in agreement with the Chief Justice. The cabinet is the cornerstone of responsible government in New South Wales, and its documents are essential for its operation. That means their immunity from production is complete. The Legislative Council could not compel their production without subverting the doctrine of responsible government, a doctrine on which the Legislative Council also relies to justify its right to call for documents. It follows that cabinet documents can never be produced until released by cabinet. No process can arise for the courts or anyone else balancing interests against each other, nor, in my view, is the analogy drawn by Justice Priestley with confidence.
Thank you. Order. Honourable members, according to sessional order, business is now interrupted.